Okay, everybody. Good morning, everyone, and welcome. My name is Gabriela Zambrano, and I'm the director of the Houston MBDA Business Center. This is our second in a series of webinars, and I appreciate your patience with us as we get accustomed to virtual technology. Before we begin, I want to remind everyone that this video is being recorded, and if you have any questions during the presentation, please write it in the chat room. Now, I'd like to introduce my colleagues, Mark Craig and Deidre Sutton, the Vice Manager, Jessica Vasquez. Our next MBDA webinar speaker is Tim Westcott, Houston District Director from the Small Business Administration. It will be held right here next Wednesday, April 15, beginning at 11:30 a.m. The topic will be SBA Disaster Assistance. Our speaker today is co-managing shareholder of Andre Myers, and he's the #1 construction lawyer in Houston, Ben Westcott. Also, we're grateful to have a guest speaker with us today, Elaine Howard. She's a shareholder of Andre Myers, and she's a trial attorney focusing on commercial litigation, real estate dispute, and employment law. Elaine Howard. Ladies and gentlemen, please welcome Ben Westcott and Elaine Howard.
Good morning, everyone. Thank you, Gabriela and Mark. We have prepared a PowerPoint presentation for today, but before we get into that, let me give you a little bit of background on who I am and what we do as a law firm. Number one, I am from New Orleans, Louisiana. I came from New Orleans to go to Rice University to go to college and play football on a football scholarship. I went to work in the construction business, and one of my very first projects on a construction project at the Woodlands Mall, I was fortunate enough to be sued. And so when my company got sued, I got put in charge of dealing with the lawyers and the documents relating to the lawsuit. The lawyer I had was not a construction lawyer, quote unquote. So I spent most of my time teaching this person all of the terminology, all of the things that I thought the lawyer should already know, because we needed to be focused on how to win our case, not on how to educate the lawyer on my business. And so when I went to my boss and I said, we're going to need a new lawyer or we're going to lose, he did like any other good boss or manager would do and said, okay, go find us another lawyer. So then I was tasked with interviewing attorneys to see who could help us with the case. And I found out that there was such a thing as construction law at that time. I worked with a lawyer who specialized in construction. He helped us get the case resolved. Was an efficient process. No lawsuit is painless, but it was efficient, or at least as efficient as I thought it could be. At the end of the case, the lawyer asked me if I wanted a job. So that's what led to my career in construction law. I went to law school and then worked part-time for this lawyer. And at the end of law school, I went to work as a quote-unquote construction lawyer. Now, you may be asking yourself what that is. Think about anything that a construction company would use a lawyer for. Negotiating a contract, analyzing a change order or delay issue, helping them get paid when they don't get paid, or helping to defend them if someone has a complaint about their construction. So that's a little background on me. This is my 21st year as a construction lawyer. And so what we're going to do today is we're going to talk about COVID-19. Thank you. Next slide, please. We're going to talk about COVID-19 and how it impacts force majeure suspensions. And then the last part I'm going to turn over to Elaine on FMLA. That's the Family Medical Leave Act and the amendments that have been put in place recently tied directly to the events of COVID-19. Now, most of you on this call are in business and have to either sign or get other people to sign contracts every single day. Some of those contracts may include provisions labeled force majeure provisions. Force majeure is a word that means outside of your control. Force majeure means some force outside of your control that impacts your ability to perform the contract. Now, if you hear a lawyer or a banker or an insurance person or any advisor tell you that they know whether or not COVID-19 is a force majeure event or not, and they have not seen your contract, then you need to stop and not act on that advice. Okay? Because in Texas, whether or not something qualifies as a force majeure event is almost exclusively determined by the language in your contract. So what we have recommended, can you go back, please? What we have recommended to each of our clients is to create an inventory of their existing contracts. And then in that inventory, create a column that says whether or not the contract has a force majeure provision in it or not. And then include the language in that provision in the third column, so that you will know which contracts you have that have force majeure language in them or not. It is only then that we can analyze whether or not the force majeure provision in your contract includes protection for COVID-19 or not. Go ahead. Next slide, please. If you are doing a project in Louisiana, the answer is different. I am not a Louisiana lawyer, but I will tell you that Louisiana follows a civil law system similar to France. And if you want to be French or you want to be from Louisiana, which I am, you're going to have to do a whole different analysis in how this force majeure applies. But generally speaking, in Texas and in most other states, contract terms control. Next slide, please. From my standpoint, a typical force majeure covers things like acts of terrorism, earthquakes, pandemics, which we have here, but again, you got to look to the specific language of the contract. In most contracts, the risk of market fluctuations is not included. What do I mean by market fluctuation? If I sign a contract that says I'm going to provide widgets at $25 a widget, and then the price of widgets goes up after I sign my contract, I can't go back to the buyer and say I need to change my price. I should have secured a product line or source of supply prior to entering into the contract to control the price risk. Just like if the price of widgets went down after I signed the contract, I would not expect a customer to come to me and ask me for a lower price on the contract just because the price went down. The same analysis applies generally to source of supply. Okay? If I make a commitment in a contract to sell someone a certain quantity of a certain item, it is presumed that I took the steps necessary to secure that source, that quantity, before I signed the contract. So in general terms, you cannot get out of a contract or be excused from a contract because the price went up or the source of supply is no longer available. Next slide, please. Okay, this details some of the items we were just talking about. Okay, if you are a person who enters into a contract with a buyer to sell something, and there is an impact down the supply chain, you can no longer get that item because it is being supplied from China, for example. You will not necessarily have an excuse for performance. You will have to do everything in your power to secure an alternative form of supply. A substituted good, a different product from a different supplier. You cannot just put your hands up and say, I'm done because I planned on getting this from China and I can no longer get it. Okay? Now, the same goes for the delay. Unless there is contract language in your favor, you cannot excuse performance or delay performance just because your source of supply is no longer available. Okay? That's why we got to look for protections in the contract, because in general, the law will not protect you. Next slide, please. Okay, same thing for storage and supply chain agreements. Price risk is on you. Okay, just because your shipper can't get something to you doesn't mean it excuses your delivery obligation to your buyer. Or just because you were counting on some trucking company or some shipping company and they're now overwhelmed doesn't mean that you necessarily are excused from performing the contract. So once we make our chart of our contract provisions, we have to apply it to the context of each situation. You have to look at what the delivery terms are, what excuses might apply, and filter that through the contract language to determine what your rights and remedies might be. Next slide, please. All right. I don't know how many of you on this call are in the construction context or not, but a typical construction contract includes language that looks like what's on this slide. And it's in the AIA, which is the American Institute of Architects form contract, the A201 general conditions. These are the standard general conditions that would apply to a construction contract. It says, if the contractor is delayed by unusual delays in deliveries, unavoidable casualties, or other causes beyond the contractor's control, then the contract time shall be extended for a reasonable time. Okay? What does that mean? That means you will get more time to perform the contract. It does not mean that you will get more money to perform the contract. That oftentimes leaves the contractor in a bad situation. Because when we're in a situation like this, more time may not fix the problem. Can you go to the next slide, please? All right. So one of the questions I often get is, what if the party that I'm in contract with tries to suspend the contract? I want to make sure that you understand there's a difference between force majeure, which is something neither party can control, and suspension, which is something one of the parties can control. Let's say you're working in an environment where the owner of the project thinks they no longer have the money to perform the project, and so they issue a suspension notice or they try to stop the project. Okay? That's what we call a suspension. That's different than force majeure. If the owner or the buyer suspends the contract, then you as the seller or the contractor have additional rights because of the owner's suspension. Let's look at a typical suspension provision. Next slide, please. Okay, so the AIA, the same contract we talked about before, says that the owner can suspend the contract. And what does it say? It's very different from the force majeure. 14.3.2 says the contract sum and the contract time will be adjusted for the cost and time caused by the suspension. Okay? That's much better for the contractor because they can get both time and money under this contract provision. Let me go to the next slide, please. The other thing I want you to look for in your contracts is a change in law provision. Many contracts have this provision, and it says that if after the date the contract is signed, the law changes, the contractor can make a claim for how the change in law increases the cost of the contract. In this particular case, you might have a stay-at-home order, right? You might get a stay-at-home order. We've all seen those, and you might not be labeled an essential business. If the change in law says you can no longer go to work, then you're going to have a claim under your contract for the costs due to that change in law. Next slide, please. The other thing I want you to do is look for emergency provisions. Some contracts have provisions that say contractor can get more money for doing emergency items. This definitely would apply to COVID-19. If your contract or your project or your situation is you have to stop, you have to shut down your facility, that is an emergency. Track the cost associated with that emergency. Make a claim for those additional costs if you have one of these provisions. Next slide, please. Okay, before we get into the FMLA, I'm going to look at one of these questions over here if you're okay with that, Gabriella. The question in the chat is, I signed a lease in the Woodlands at the end of August 2019 for 5 years. It has taken lots of resources to see the start. I may go bankrupt to restart our efforts. I have written to my landlord telling them I'll vacate by this month's lease deadline. They have responded they intend to take me to court. Okay, let me suggest to you, we need to look at the lease agreement itself. Okay, there are many programs out there that would allow you to request an extension of the payment terms of your lease. A lot of it depends on whether your landlord is an institutional landlord or an individual landlord. I'm happy to consult with you offline. I'm nervous answering this question with a lot of detail without seeing the lease. So our email addresses will be in the presentation, and you can email Elaine or I after the presentation, and we'll do a more detailed review of your question and try to get back with you. With that, I will hand it over to Elaine for the FMLA portion of the presentation.
Well, thank you, Ben. And I'm happy to, again, if you have some questions that come up, put them in the chat, and I'll address them if they're general questions as well. I know Ben's going to stay on the line as well, but probably one of the biggest changes in employment law of the last 10 years or so has been the institution of a temporary but a significant paid leave act on the federal level. This is the first national paid leave we've had in this country. And I don't know how much of you have been following some of Texas law, but we've had some of the municipalities throughout Texas try to institute some local paid leave. And so far, all of those have been stopped through lawsuits and through the court. So this has been a very significant piece of legislation that took effect very, very quickly. And we are still trying to catch up and figure out exactly what the rules are for the interplay of both the employee's entitlement to leave and how basically this tax credit works, what documentation you need. So I'll walk through some of those things as we talk through this presentation. But as probably most of you know, it took effect April 1st. Employers had about 15 days to figure this out based on the statute, but we didn't have any regulations in place until right about April 1st. So it made it very challenging to figure out some of these ins and outs. It applies to all businesses with less than 500 employees, which is a big change from the Family Medical Leave Act, which only applied effectively to larger employers and carved out the employer, some of the smaller employers. It was a little complicated, but this is something that was hinted at in the statute and then discussed in more detail in some of the more recent regulations that have come out. But there is potentially a small business exception for employers under 50 that requires some documentation internally that you would basically face a severe financial hardship to pay some of this paid leave, but it only applies to the portion of leave for people to care for children whose schools or daycare are closed because of COVID, and it does not apply to the initial basically 2-week period where employees are entitled to the paid leave for either their own COVID-related illness or to take care of someone else, a family member's COVID-related illness or symptoms of COVID. So the leave that they've set up is a little complex. There's actually 2 different kind of periods that apply, which has made it very confusing for a lot of people. But there is that initial 2-week period that I mentioned where employees are entitled to paid leave either because they are needed and cannot telework in order to care for a child who is off school or daycare because of a COVID closure, or for the employees or family members' own symptoms of COVID or diagnosis of COVID, or to comply with a quarantine order issued by a governmental entity. The leave that you pay is subject to a tax credit. It is intended to be almost like an immediate wash. Go back for employers, which is great. So the leave is that you can obtain that tax credit and that you have to pay employees is capped. And it is capped at different amounts depending on whether the leave is to care for actual symptoms of COVID of the employee or a family member, or whether it's for care for a child. I mentioned there's sort of two segments to it. That's a maximum of 2 weeks, capped at 80 hours, although it's less for a part-time employee. If the part-time employee normally works 20 hours a week, they would basically get 40 hours of leave because it's 2 weeks worth of paid leave. If the employee has to continue to be home to care for children, that employee is then also entitled to basically weeks 3 through 12 of paid leave, which again is subject to a cap and is also subject to being netted out through this tax credit. And there is a 30-day grace period that the Department of Labor has confirmed that if you are trying to comply with this law, there are a couple of requirements, but for the first 30 days, there is a little bit of a grace period as we all sort of figure this out and we read the regulations and we try to figure out the interplay between the Department of Labor and the IRS and some of the other regulations that apply. Let's go ahead and go to the next slide. So here are the specific categories that I mentioned and the caps that apply to them. So as you can see from this chart, there's sort of 3 different categories here. There's the category of a parent caring for a child because of a school closure, care for a quarantined individual or substantially similar care, and then if the employee is quarantined by a government order or on the advice of a healthcare provider or because of a diagnosis or treatment at COVID. And as you can see, all of the payments to be made to employees if you are out because of a school closure are capped at $200 a day. So, obviously if you have a lower wage earning employee, that cap's not going to apply. But if you have, a higher wage earning employee, that cap could certainly come into play. As you can see, there are some different, whether it's emergency paid sick leave, so that's the 2-week maximum of 80-hour provision, or the emergency family medical leave, different things that are covered. And so this chart is helpful, I think, to kind of try to understand that 2-part dichotomy between when you're entitled to that first potentially 80 hours of leave, and then when you're entitled to this additional 12 weeks. I think a lot of people heard this and they heard 12 weeks of leave, but it is really much more limited than that. If this is an actual COVID illness or injury, it's just that 14-day period, which was designed to basically kick in because, typically if you are sick because of COVID, 2 weeks is a reasonable, recuperation period for that. So that's why this initial period of leave was set at that time period. So let's go to the next slide. One of the things that hopefully people have done, because this did go into effect on April 1st, was you are required to post a poster with all of the other posters that you've got. So it's not any different really than anything else. Print it out, tack it up to the bulletin board where you have everything else, except that what they've recommended, because so many people either have a completely closed place of employment or everyone is teleworking, is that if you do have workers remotely working, and you have some sort of bulletin board or some way to communicate with them, that you distribute this poster to your employees so that you are providing them with notice, because obviously if the office is closed, they can't come in and see the poster. So that is one little bit of a difference between kind of your normal poster requirement and this poster requirement. Let's go to the next slide. Oh, and I guess that's it. I'll mention one of the things that we've been struggling with a little bit, and I alluded to this, is what documentation do you need in order to substantiate both the request for leave and the IRS tax credit? And they have recently been starting to publicize some information about that. I think there's been a lot of confusion about, do I need a certification? Can people get in to even get a certification about this? And they confirmed that if an employee requests leave and requests leave for one of the reasons that are enumerated, the IRS actually does want to see in your file some confirmation about, the fact that the employee has requested it, the employee's name, the reason for leave, and if it is because of health-related reason, the name of a healthcare provider who has suggested that that employee stay home, or confirmation for staying home because of a quarantine order, documentation or confirmation about what order it is that they're complying with. So that's kind of a new twist that was added last week that has made it a little bit confusing to try to figure out what you need to have in your own internal documentations in the event of an IRS audit if you do take this tax credit.
I do have a good question here on the chat board that I'd like to address. One piece of advice for small business owners in this situation, I'll actually break that into two. Number one is to have regular conversations with your key customers about what steps you're taking to overcome the impact of COVID-19. Every single one of those customers is hearing from your competitors about why they can't do something. Okay? What's going to stick in the mind of those customers is what you're doing to continue to service your client base at this time. How you're trying to think outside the box. How you're trying to make sure that client's business is supported. So that's my first piece. My second piece is, once you review your contracts to see what your remedies are, you got to effectively track the costs that are changing because of COVID-19. You can't just keep one set of books and establish your entitlement to a claim in one of these situations, because it doesn't separate what your normal operating costs are from what your additional operating cost or project or contract specific costs are. So those two pieces of advice are most important to me. We've saved a lot of time for questions, hopefully. And so Gabriella, I'll turn it over to you to see if you want to try to facilitate some more questions. We've answered the questions on the chat.
Okay, well, thank you so much, Ben and Elaine. And if anybody wants to have a question, since we still have half an hour, please unmute yourself, or you can type it and I can unmute you if you have extra questions.
One thing I'll add to what Ben said while people are thinking of questions or typing anything in addition to communicating with your customers, we're really recommending over communication, if at all possible, with your employees. A lot of employees are, even if they're still working, are very unsure and uncertain about, the financial status of the company, about what the future plans are. And obviously, depending on what your business is, it may, whatever you have to communicate may be more or less reassuring. But I think that all of them want to know, need to know. I mean, none of the employers out there, are excited about layoffs or excited about furloughs. but certainly if you are continuing your business and that you do still have employees out there that are working from home, working a reduced schedule, all of these communications about not only the financial viability of the company, but what the instructions are and what the rules are if they do interact with someone, a fellow employee, someone on a job site, a customer who has COVID symptoms, someone who's coughing. I mean, what are your instructions to your employees about how to interact with people, or what to do if they themselves end up with symptoms? Who do they call? Do they call a supervisor? And I think it's really helpful to make sure that all of them know their instructions, because we're hearing lots of stories about, people showing up at job sites or showing up at customer sites coughing, and then, that's going to end up pretty, in some bad circumstances, getting people fired off the job, customers no longer being a customer if you've got employees that are, in this day and age, acting in ways that give people concerned that they may be ill. We even got in my house a notification that one of our the trash company had an employee that was diagnosed with COVID, and so now I know that someone who handling my trash can was diagnosed with COVID. So that's just really crucially important that employees know what their instructions are, what their plan is to avoid blowback to your own business.
Well, thank you so much. Well, I know we have more than 40 participants, and I'm wondering if they're just afraid of asking a question or what's going on, but I also want to remind everybody that Wednesday, we're going to have a webinar with SBA, and the following Wednesday, we're going to talk about HR issues. But yeah, I'm very concerned, like where you were talking about those construction workers that were coughing. And even, I don't know if you saw, like HEB also mentioned that a couple of them got for 2 locations, they got COVID-19. So everything is very scary right now. And everyone is trying their best to communicate. Does anybody have an extra question, a final thought? You would like to unmute yourself? Right now is almost the time before we're going to say goodbye. No? Okay. Well, they're being pretty shy because I'm sure they have lots of questions regarding.
After the webinar is over, the questions aren't free. They're free right now.
Yeah, I don't know what to tell you. I mean, we've been getting a lot of phone calls regarding lawyers, regarding what to deal with this, but now they're a little bit shy. Maybe they don't want to ask personal questions, but this is a time to ask.
If I could reiterate something that was said early on in our planning for this webinar, we know that it's difficult to decide what to do. But unless you know what your legal rights are and what your contract provisions say, you can't listen to the news, you can't read the newspaper, and you can't figure out how to fix these situations from there, because general advice it doesn't fix the problem. You have to get specific advice for a specific problem and put it in context. So we're here to help. I was joking about the free part. We're also willing to give you consultation in connection with your decision on whether or not to engage our firm. So there's a couple of questions popping up. Look at this. Elaine, one of the questions is, if we have less than 50 employees, do we need to post the poster?
You absolutely do need to post the poster. If you have less than 50 employees, you are still subject to the first 2-week period of paid leave for employees who are, sick with COVID or COVID-like symptoms, or taking care of a family member who is sick with COVID or COVID-like symptoms. So you are still subject to, that paid leave. You're just not subject to the portion of leave that allows employees to take off for the childcare related expenses. So yes, you should post the poster, and yes, you should be aware of the, of the requirements on your company for paying the paid leave.
Got another question on here. It says, going forward, what do you recommend for signing new contracts? Here's what I recommend. I recommend a paragraph entitled COVID-19. And that paragraph should say, we do not know what the impact of this situation will be, and we reserve the right to ask for more time and more money once we can determine what the impacts are. Okay? So, make sure that you specifically address COVID-19 and give yourself room for more time and more money when you can assess what the impacts are going to be. Okay? There's another question here about terminating a residential lease to a dorm. Generally speaking, you need to ask what protections the property management company has taken to protect the other residents. You need to ask for that information. I don't think you can automatically terminate your lease on that basis. I think you need to evaluate what steps were taken to make the premises safe, and then go from there.
There's a question here from Vicky, and I'm not quite sure what the question is. It's how long will it take for the government to help the employee? So one thing, I don't know if this is what you're asking, but this is what I'm going to answer. The Texas Workforce Commission has just issued some guidelines for employers that I think all of you should take a look at. They relate in part to how the Texas Workforce Commission is going to deal with some of the chargebacks. Normally, if you lay off a bunch of people and potentially your rate that you're going to pay for the unemployment to the TWC can increase, and they have specified recently that they're not going to charge back employers for the COVID-related layoffs. So I would recommend that you take a look. There's some information from the TWC on how you specify, particularly going forward as hopefully things calm down a little bit, or, whenever we get back into our more regular lives, whether a layoff is still related to COVID or not. So I'd suggest you take a look at that.
A question from Mr. Bowles. With the Dallas restrictions and the inability to, and I'm referring to the Dallas stay-at-home order, and then also the safety guidances issued by Dallas County, I do think there are grounds for requesting schedule relief. Whether or not you can get money for that is going to be determined by your contract. Happy to help you assess that situation. We have already been asserting claims on behalf of both general contractors and subcontractors in the Dallas market because of the same concerns you have raised.
Great. We'll be in contact with you.
Thank you.
Well, I don't see any more questions. I don't know if people are still thinking about it or what's going on. But I think we had a lot of great information. I know there's a lot of people out there who are still looking and trying to learn how to survive this crisis. Do you have any more final words, Ben and Elaine?
I just want to say thank you to you and Mark and your team for putting this together for us, and thank you for making it so accessible to all of your members. And we appreciate the opportunity to be here with you today.
Absolutely. Thanks for having us.
Well, again, everybody, thank you so much. Thank you, Ben and Elaine. They did everything. I mean, hopefully a lot of people are probably going to send you an email directly. Also, I want to remind everybody that MBDA is still working remotely. And if you want any questions, feel free to send us an email, questions. We're here to help you guys. And again, thank you again, everyone. Bye.
Bye-bye.